2018, when the Cambridge In 2018, when the Cambridge Analytica story broke worldwide, the Indian government issued a stern notice to Facebook. And then something awkward happened. Legal experts pointed out that if an Indian company had done exactly what Cambridge Analytica did, harvested tens of millions of profiles and used them to target voters, it would not have been guilty of any specific data protection offense under Indian law. Not one. The world's second largest internet population, hundreds of millions of people transacting, banking, messaging, and applying for government services digitally, and no law that could name what had gone wrong, let alone punish it. Today's episode is about that gap, because you cannot understand what the DPDP Act is until you understand the emptiness it replaced. You're listening to DPDP Daily. I'm Hamid Singh Kapoor. I've spent my career running large programs and portfolios, the discipline of making complex things actually happen. And for the past few years, I've brought that discipline to India's data protection law. I wrote the DPDP Act Compliance Handbook, From Law to Ground Reality, and this show is that book, opened up one episode at a time. If you're new here, the 30-second background: in 2023, India passed its first comprehensive data protection law, the Digital Personal Data Protection Act. In November 2025, the government notified the rules that make it operational on a phased clock that runs to full enforcement in May 2027. Together, they decide what every company, hospital, school, app, and shopkeeper in this country may do with your personal data and what you can demand when they get it wrong. 15 minutes a day, no jargon, real answers. Let's get into it. Let's start with what India actually had, because the old framework wasn't nothing. It was worse than nothing in one specific way. It created the impression of protection without the substance. The Information Technology Act came into force in 2000, built for a different internet, an internet of email and early e-commerce, not platforms and profiling. In 2008, Parliament inserted Section 43A, and in 2011, the government issued what practitioners called the SPDI Rules, the Sensitive Personal Data or Information Rules. Together, these were India's data protection law for over a decade, and on paper they sounded reasonable. Companies handling sensitive personal data had to follow reasonable security practices, and if their negligence caused wrongful loss, they owed compensation. Now watch the framework fall apart as I list what it didn't do. It applied only to body corporates, commercial companies, government departments processing the data of a billion people, outside it, individuals, outside. The platform shaping daily digital life sat in definitional gray zones. It protected only a closed list of sensitive data, passwords, financial information, health records, biometrics, and a few more. Your name, your phone number, your address, your location history, your purchase behavior, and the everyday data that actually gets traded and abused enjoyed essentially no protection at all. It gave you no rights, no right to know what a company held about you, no right to correct it, no right to erasure, no right to withdraw consent in any meaningful way. The word consent appeared, but as a formality to be collected, not a control to be exercised. There was no regulator, no authority whose job was data protection, no complaint desk, no investigative machinery. Enforcement meant one thing: proving negligence in a civil claim. Think about what that demanded of an ordinary person. Establish that a company's security was negligent, prove your specific loss flowed from it, and sustain years of litigation against corporate legal budgets. As a practical remedy for a shop worker in Indore whose data leaked from a loan app, it was fiction. And there was no breach disclosure duty. A company could lose your data and simply never tell you. Through the 2000s and 10s, reality kept testing this framework, and the framework kept failing the test. In 2017, reports surfaced of enormous leaks involving Indian telecom subscribers' details, and there was no legal obligation to even disclose them. The Cambridge Analytica episode exposed the offence gap I opened with, and running underneath everything was Aadhaar, the world's largest biometric identity database, holding the identity of over a billion Indians, raising a question the IT Act had no vocabulary for. What does the state owe citizens when the state itself is the biggest data processor in the country? Meanwhile, the scale kept compounding. UPI made payments data ubiquitous. Cheap data plans brought hundreds of millions online for the first time, often people encountering consent checkboxes in a language they didn't read on services they didn't fully understand. India was building the most data-intensive society on earth on top of a legal foundation designed for the Internet of 2000. By the late 2000s, three pressures converged. The constitutional pressure, which deserves and gets its own episode tomorrow, after the Supreme Court declared privacy a fundamental right in 2017, making a statute legally overdue rather than merely desirable. The economic pressure, Indian IT and services companies needed credible domestic law to keep processing the world's data, as regimes like Europe's GDPR started judging partners by their home protections, and the social pressure, every leak, every unexplained telemarketing call that knew too much, every loan app scandal fed a public sense that something lawless was happening to people's information with nowhere to complain. Let me make the emptiness personal, because statutes fail people one at a time. Picture any Indian in, say, 2019, call him Suresh, a schoolteacher in Nagpur. He books a flat viewing through a property portal. Within a week, his phone becomes a public utility. Builders he never contacted, loan offers, interior decorators, all greeting him by name, all knowing his budget. Somewhere, his enquiry was sold down a chain of brokers. Now walk Suresh through his legal options under the old framework. Was his name and phone number sensitive personal data under the SPDI list? No, so the rules protections largely didn't apply. Could he demand to know who sold his data? No such right existed. Could he complain to a data regulator? There wasn't one. Could he sue? Only by proving in civil court negligence and quantified loss for the injury of being telephoned. Every path ended in a shrug. Multiply Suresh by a few hundred million, and you understand why data protection in India became a phrase people said with air quotes. And there's a subtler failure worth naming: the era perfected consent theatre. Because the SPDI rules did mention consent and privacy policies, companies produced them, endless scrolling documents drafted to be unread, agreed to by a checkbox that unlocked the service. The form of consent without any of its substance, no specificity, no real choice, no withdrawal worth the name, no consequence for ignoring your own policy. That decade of theatre is precisely why the DPDP Act's consent standard reads the way it does: free, specific, informed, unconditional, unambiguous, affirmative, each adjective a repudiation of a specific trick the old era normalized. When compliance teams today complain the new standard is demanding, my answer is it's demanding because of what the last regime let everyone get away with. That's the inheritance the DPDP Act walked into, and it explains the Act's design choices better than any theory. Why does the Act apply to everyone processing digital personal data, government included, rather than just companies? Because the 43A carve-outs failed. Why does it protect all personal data rather than a sensitive data list? Because the list approach left the most abused data unprotected. Why does it create enforceable individual rights and a dedicated board with real penalties? Because a compensation remedy nobody could realistically use had been tested for a decade and found empty. Why mandatory breach reporting? Because silence was the norm and it protected exactly the wrong party. One honest closing note: because this show doesn't do mythology, The DPDP Act is not the maximal law reformers wanted. It carries generous exemptions for the state, it dropped ideas earlier drafts contained, and serious people criticized both. We'll take those debates head on in later episodes, but whatever its imperfections, it replaced a framework under which the honest legal answer to "what are my data rights" was, for most practical purposes, you don't have any. That is why India needed this law. That's today's episode of DPDP Daily. If it made this law a little clearer, do one thing for me. Send it to one person who needs it. That's how this show grows. Everything I covered today, with the templates, checklists, and audit frameworks behind it, is in my book, The DPDP Act Compliance Handbook From Law to Ground Reality. And I post one practical DPDP insight every morning. Find me on LinkedIn and on X and Facebook as well, under Harmeet S. Kapoor. One important note: this is education, not legal advice. For decisions about your organization or your rights, take proper professional advice on your specific facts. New episode every day. I'll see you tomorrow.